Good day, everyone, and welcome. My name is Jordan Wright, and I'm delighted to open today's Mondac webinar in association with Gün Partners for World IP Day, focusing on access to medicine, compulsory licensing, and protection of patent rights. We're joined today by a wonderful panel to take us through today's discussion. Selin Erciyas joined the firm in 2006 and became partner in 2014. She specializes in life sciences and intellectual property with a special focus on patents and utility models. Selin has been involved in a number of advisory and litigation matters in all fields of IP and has been handled hundreds of contentious and non-contentious administrative operations and court actions involving intellectual property rights, particularly in relation with protection of patent rights. Aysel Korkmaz Yatkın joined the firm in 2008 and became partner in 2020. She specializes in intellectual property, insurance and reinsurance, dispute management, and business crimes and anti-corruption practices with a special focus on patents and utility models. With almost 15 years of experience on patents, she has been providing consultancy on all matters related to the patent law and has been leading numerous patent actions. Camilla Bellany is a partner in the leading European IP firm Carpmaels and Ransford. She works exclusively in relation to the life sciences patent matters, representing clients in the UK and on multi-jurisdictional litigation and advice. She has a degree in genetics, and having spent time in-house at a large biotech company, Camilla has developed a very strong understanding of both the technical and commercial world in which her clients operate. So now, before I hand over to our panel today, a quick housekeeping item. You're able to submit questions to today's panel by typing the questions into the questions pane of the control panel. You can submit questions at any time, and we will endeavour to answer as many as possible during our Q&A at the end of today's session. So it's now my pleasure to hand you over to our panel to begin. Thank you very much.
Okay, so thank you for the introduction, Jordan, and hello, everyone. Well, I'm very happy to be together once again in celebration of the IP Day, and thank you for joining us, of course. This year we chose kind of a quite debated topic in celebration of the IP Day. As we all know that we experience and we're still experiencing a serious COVID-19 pandemic, and from the day one of this pandemic, the IP rights were the most debated issue, if they are, promoting the innovation or blocking the access to vaccine or maybe manufacturing of it, etc. and etc. So, yeah, pandemic brought really many discussions. But what, in my experience, we saw truly that the intellectual property rights helped us a lot to reach a cure at first hand. But today, back that time, the compulsory licensing issues were the main issues seen as a tool by the governments in order to battle with the pandemic, even there was no cure, no true cure. But today, finally, we have the vaccine, and once again, the IP rights are the most debated one under the most recent discussion of the IP waiver. So I think at this point we should stop and think a little bit, especially in terms of what really incentivized the innovation and research when there was no cure. And you will all remember the first day of the pandemic. First we faced with it, how much we feared and how much we thought that when will be a cure, when it will come, and how much lives will it cost, etc. Until it come, of course. So, and we also experienced that despite many compulsory licensing threats and many accusations, in fact, directed to the pharma companies, we saw them joined to patent pools, opened their know-how, and shared their technology with the ones who are willing to manufacture the vaccine, or at later stage, of course, or first to contribute the innovation for a vaccine. So I think I will say the last thing that I should say at first, I think we should give the credit of innovation for all of this procedure and for coming today. Even today, we're not all together in a very safe position because, first of all, not the whole world could be vaccinated yet. And secondly, there may be another pandemic waiting for us, or a new, hopefully not, of course, but maybe a new variant of COVID-19 is maybe waiting for us. So I think it is important to look at what we experienced back to 2 years, and what we should learn from that experience. In that terms, again, in my opinion, it is sad to see that once more the intellectual property rights seems to be under the spotlight and seems to be accused by many parties by as a tool that is blocking to first innovation and now to access to vaccine. You may have heard there is this proposal brought by South Africa and India before the WTO. And this proposal is the IP waiver proposal. It is mainly saying that let's remove all IP rights confronted by TRIPS among 164 members of the WTO. And the expectation is rapid access to vaccine. So this was brought, again, as I said, by South Africa and India back in October 2020. And then there was this revised version of this proposal back in May 2021, which only, put some kind of specifications like the term of the IP waiver, that it should be not last at least than 3 years, etc. And it should focus on the health products and technologies for prevention, treatment, or containment of COVID-19. But still, there are lots of, ambiguous parts for the waiver. But my point will not be what is not really ruled under the waiver, but actually that, in my opinion, of course, that such a waiver will not provide us nothing but a rapid access to the vaccine. So I would like to touch two main points in that terms. One is the procedural one, and the second one is the substantive one. The procedural one is about how to, reach a consensus among 164 member states of the WTO on such a thing, on waiving the IP rights confronted by TRIPS agreement. So, as I said, the proposal was made back in October 2020, and till today, there could be no consensus, and we are not expecting for any such consensus anytime soon, which means that it is not a correct way to find a rapid solution to access the vaccine. You may know that European Union is quite hesitant with this kind of IP waiver, whereas US wants China to be excluded from the scope of this waiver, and it also wants the waiver to be focused on the vaccines only. These are only a couple of examples to explain how difficult it will be, to find a consensus among all these countries and how much time it will require. But the more important thing, in my opinion, is that it will be substantially useless to waive the IP rights. It won't provide any of us to ramp up the manufacture or access to the vaccine. That is because we have the proofs coming from last 2 years that the IP rights are not the real obstacle in front of the access to vaccine or innovation or manufacturing more vaccine. You may remember that this company Moderna had said back in 2020 October that it will not enforce any of its IP rights to anyone that wishes to come up with an innovative cure against COVID-19. So it basically removed the barriers coming from its IP rights. But what happened? Did any of company could come up with a solution or come up with a, by using the IP of the Moderna, come up with a, innovative cure? No, unfortunately. So if removing IP would enable access to vaccine, then I would think that, first of all, India, which is the co-leader of this IP waiver proposal, and the rest of the countries who are supporting this IP waiver, has this compulsory licensing provisions in their national law. So, it's also a mechanism to remove the so-called IP barrier, if it is a true barrier. But no such mechanism could be, properly run, and none of such mechanisms could accelerate the vaccine manufacturing or access to vaccine. That is mainly because it is not what we need when it comes to complex biologics like messenger RNA vaccines. It is not what we need that that is disclosed in the patent documents. We need know-how, we need technology transfer, we need appropriate manufacturing facilities, we need expert employees, and we need the people as well to be ready and persuaded for vaccination. And we all know that the patent document, I mean, it of course discloses whatever the technique it innovatively found. But when it comes to the vaccine manufacturing, what you need to ramp up the manufacturing or to start up manufacturing is not cited in the patent document. So what is really needed is collaboration, actually. So willingness of the patent owners and to find amicable solutions, amicable ways and collaborations between patent owners, innovator companies, and developed countries. So you can have this technology transfer, you can have this know-how, etc. And there is no legal mechanism, as we all know, that you can force anyone to share the trade secret or the know-how or the technology, of course. One very interesting thing I would like to mention at this point, that many of us have this compulsory licensing mechanisms and provisions in our law, but particularly India has a quite striking provision in its Patent Act under Section 66. And accordingly, if it deems necessary, the government of India can revoke a patent for public interest. So can you imagine, there is no procedural steps to be taken like the ones that you need to take when it comes to a compulsory license, because this point also been raised by the IP waivers advocates. They are saying that, well, IP waiver is necessary because, compulsory licensing procedures are too long, as if it is short to get consensus among 164 members of WTO. But there is such a provision, as I said, in the Indian Patent Act. So there will be no such, voluntary license application for the patent owner or discussions on loyalty. The government can simply revoke the patent. But this mechanism has also been not used, because I think inherently India knows that, although it's the co-leader of this IP waiver proposal, it knows that it will be useless. The patent document is already there, but the trade secret, but the know-how, but the technology is not there. So it will not help anyone to ramp up vaccination or vaccine manufacturing, etc. Another proof of this actually was put openly in this affidavit. You must have heard about this. There's this affidavit filed by government of India to the Supreme Court of India during the discussions on why compulsory licensing mechanisms are not run during this COVID-19 pandemic. And the government in this affidavit exactly said in paragraph 44, I will read it, that in the current scenario, the main constraint is in availability of raw materials and essential inputs. Therefore, any additional permissions and licenses may not result in increased production immediately. This is the own words of the government of India, which I totally agree, actually, by the way. So I think it is in that terms very clear that neither the compulsory licensing mechanisms nor the IP waiver will help anyone to ramp up vaccination or increase manufacturing of vaccines, because especially the lack of, as I said, know-how, technology transfer, appropriate manufacturing sites, etc. and etc. But there are two other points that we must consider. Of course, you may think that what is more to consider? If it is useless, just leave it. Yes, I do agree, but there are two more points, because it is very important to understand how detrimental can it be to waive IP rights in long term. What I mean is, okay, we're still within this pandemic issue. It is not over yet, and it will not be the last one, maybe. So we need more innovation, and we need more incentive to innovate and to come up new research. You may know that this COVID-19 vaccine studies were not, directed to this aim. These studies were started years ago, and the aim was, cancer studies and some other studies as well, by the way. But then, because and thanks to these studies were existing, they could be converted for a cure in the COVID-19 pandemic. So we all know that this messenger RNA, these are complex biologics. So there must be cooperation, even between the originator, the innovator companies who wants to develop and manufacture these messenger RNA vaccines. And we know that, for example, there had been joint development partnerships between BioNTech and Pfizer, between CureVac and GSK, and there had been some other collaborations for the production as well, as we all know, which says that none of these companies could alone battle with this pandemic. There had been collaborations, there has to be. And the backbone of these collaborations were IP rights. So if you remove the IP rights, how you will motivate these companies to collaborate, to come together, how to open each other the know-how and the whatever they need to for that collaboration. If you remove the IP, you make them to think that, well, the next time I will also be able to lose the IP. So what is the incentive for me to, waste lots of money here? And one last thing that similar to this point, as I mentioned, that these points for me are side points in front of the substantive useless of the IP waiver, is the regulatory route that a biosimilar must pass in order for a vaccine to launch, of course. Every country's health authorities wants the biosimilar products to be highly similar with the biologic product, with the reference product. So what is required is to be, these, efficacy, safety studies, clinical trials to be submitted to the health authority within a marketing authorization application file. And if you lose the collaboration of the, reference product owner, you have to put them together on your own. So can you imagine all these clinical trials, tests, studies, how long time will it take to put them together? And maybe it will not be possible at all in considering that the shortcomings in terms of finance, etc. and etc. So again, it, in my opinion, emphasizes the importance of the collaboration. And really, I strongly believe that the IP waivers or even the compulsory licenses is useless for that kind of battles like we recently had while battling in COVID-19 pandemic. So I think we must keep in mind that intellectual property rights do play the key role in delivering vaccines. And it has happened quite fast, by the way. You will remember that within a 1 year time, the first studies were completed. So a waiver of IP protection, I think, because of it will ruin the collaboration and incentive for innovation and motivation of the innovator companies, etc. It will leave us all quite struggling in case of a new variant of COVID-19 or, for example, in front of a new pandemic. One last thing is I think the advocates of IP waiver ignore the significant role of IP to motivate the innovation and to incentivize the collaboration. They do ignore it, and among hundreds of articles I read, I did not see any other thing put, instead of IP to incentivize the innovation or to motivate the, innovation and to come up new research, etc. So if it is not IP, what will be it? We need to think about it. And I think I'm not the only one who's advocating for it, let me say, because what I felt that when I learned that the European Union come up with this harmonization of compulsory licensing procedures, they must have thought that, wow, waiving IP rights, I mean, it is a huge step. Let's not do that, but find some other ways maybe to, because one of the critics of the IP waiver advocates was that the procedure of compulsory licensing is too long. So maybe they wanted to start, I mean, the EU wanted to start to simplify it in order not to drive the, way to an IP waiver. So, Aysel, can you please tell us about this harmonization issue? And I really would like to know if it will work out.
Yeah, thank you, Sinem. And before I move on this European Commission's call for evidence project, I would like to just briefly tell that I really totally share your ideas. You already, mentioned the key points. Its collaboration is so important. Maybe the key solve the issue is collaboration, not the waiver of the patent rights, or maybe even not the compulsory license. Let's see. Yes, I would like to mention a European Commission on call for evidence project. Actually, the European Union says it wants to make compulsory rules more efficient, but neither drug makers nor IP critics believe that it will actually help produce more vaccines. As you also mentioned, that it's not easy to produce vaccines. It's so different from the normal, pharmaceutical products. It needs lots of things, technologies, or different ingredients, formulations. It really needs high technology and facilities, etc. And as we all know that patents are most powerful types of IP and are key in supporting the EU to build a European health union and a common pharmaceutical strategy in Europe. That's the reason the European Commission is currently seeking evidence on the impact of harmonized mechanism for the compulsory licensing of patents across the globe in emergency situations, including another pandemic. Hopefully it will not come, but we need to get prepared, of course. While it hasn't come up with really a concrete proposal yet, but the Commission is considering policy options such as EU-level compulsory license and a streamlined procedure for exporting goods procedure under such a license. The main problem here, the European Commission really wants to solve, is that compulsory licensing is governed by fragmented procedures across the different EU member states. For example, domestic compulsory licensing in the EU is governed by national laws, and compulsory licensing for exports are governed by regulation under number 816/2006. So the call for evidence that I'm mentioning, that the project of the EU also aims to assess the regulation provides the most effective procedure in line with the, of course, TRIPS. The Commission considering a few options. These are non-policy change, non-legislative measures, or legislative changes. Or the alternative way is a combination of legislative and non-legislative measures. Of course, we need to keep in mind that Commission's analysis will also consider the best way to calculate the fair remuneration. As far as I know, the feedback period is going to end by the end of tomorrow, because the Commission aims to adopt this impact assessment in the first quarter of the next year. Now I really want to share some opinion and feedbacks on the EU project, call for evidence project, let's say. For example, the argument from the pharmaceutical industry, they say compulsory licensing won't change the fact because only a limited number of companies have expertise and capabilities to make products such as vaccine that we are discussing. Another opinion from Christian Pierce, he's the General Counsel at the European Federation of Pharmaceutical Industries and Associations, says that harmonizing the rules would make the threat of an EU-wide compulsory license more even dangerous. He also warns that aggressive interventions from the governments won't solve the problem. You still need to find the right partner companies to scale up the production. But of course, not everyone in the industry is so, let me say, skeptical. Adrian Spillman from the Vienna-based director of IP at vaccine developer Balleny says that it could be a positive move as long as the use of compulsory license is restricted to emergency situations. This is important. And it will also, he says that it could help expand production capacity because you will have a bit more confidence. You will not be sued by the clever law firms during this pandemic. Now I would like to mention about some feedbacks on the Commission's call for evidence, more detail. Two citizens, one from Italy and one from Slovakia, expressed their views as against the Commission's consideration to adopt a more uniform EU-wide compulsory licensing procedure because they believe that current legislation is difficult for exceptional situations and anything further could lead to exploitation of the system, interestingly. And other feedbacks from Federal Association of German Patent Attorneys, they submitted quite a lot, couple of pages feedbacks. They say if compulsory licensing will be harmonized through the EU, it must remain for absolute exceptional cases, for public interest only, and must be granted in a fast, expedited way. Any measures to create uniform regulations must aim to give research and development companies a strong legal and economic position, as it has been case up to now, of course. And they also say that when it comes to waiving the patent rights, one must know that waiver will not lead to sufficient and fast manufacturing of vaccines, as Sinem explained in detail, and we already explained that not only legally, technically it's not possible to produce vaccine if you waived all the patent rights. So it's not a realistic solution. As we know, manufacturing also requires the know-how of the patent owner. As Sinem again said, I don't want to repeat again, but it's important to understand the reality that this know-how is not always inferable from the patent description, and compulsory disclosure of know-how does not seem legally enforceable. And in February 2022, BioNTech declared that they will be investing in container based on modular vaccine production facilities in Africa, and they are expecting to start the production of the vaccine after 12 months after the delivery of the first assembly kit. Can you imagine? This is only the, we are talking about the container to carefully and rightfully to carry all the vaccine. And it started only, it takes 12 months to just deliver the first assembly kit. So these are all shows that even with the know-how of the patentee, the manufacturing takes a year, and it's not that there is no any fast process. We need to understand. For all these reasons, constructive cooperation with the patent holders and biopharma companies should be supported for expeditions, the fast solution. And also, when I read and examined all the feedbacks, they also say that the EU call for evidence misses several key points, like the need to recognize more strongly that the know-how is largely supported by public funding agreements, and these agreements could be one of the important points that needs to be considered. And again, a manufacturer operating under compulsory licenses without know-how cannot be successful. This is for sure. We had some examples. On the other hand, certain IP professionals believe that compulsory licensing could help expand the production capacity as long as they restrict it to emergency situation. So harmonization within the EU might be beneficial, but the bar for compulsory license should be set high. This is one of the key points that we are underlining it. So it seems that the best way to encourage the patent owners to cooperate and share technology and know-how. These are all the European Commission's projects, and also I shared a few feedbacks on this project. Sinem. These are from my side.
Sorry, thank you. I think it is time for us to turn to Camilla, because we all made our points that IP waiver is useless, even compulsory licensing as it has hurt us. I mean, even you harmonize the procedure. So what is the solution?
Yeah. So yeah, thank you both. And I suppose just before I start, I just wanted to say I also agree with much of what you said, or really all of what you said in the introduction, Selin, particularly regarding the waiver and the challenges that I see with that. And also just wanted to mention that the UK, as recently as the 8th of April this year, has published a research paper confirming that it agrees with much of what you set out, and in particular, they've specifically said that they don't support the waiver, and they argue that there is no evidence that waiving IP rights would help address the inequitable distribution of vaccines, and instead would indeed undermine the framework which in fact incentivised and the development of new products that ultimately helped us with the vaccine. So it was just to add to that. And also in respect of compulsory licenses, in preparing for this, I had a really good look to see if I could identify any kind of UK-based compulsory licenses that may have led to any progress in this regard. Obviously, kind of alongside the information that Aysel has just shared, and I've not been able to identify any use of that system, which of course exists in the UK as it does elsewhere. There has been a little bit of commentary from our judges regarding its availability, the extent to which it might be used, actually not in cases to do with COVID-19, but cases that have gone on, judgments that came down just as the pandemic was announced, confirmed by the WHO. So there was obviously at the beginning of the pandemic some thoughts that might be an interesting way to move forward, but actually it obviously hasn't come to fruition in the UK. And we of course also have Crown use, which is the sort of more direct access route where the government can take over and make the decision to allow the production without patentee's permission. But actually even that, Justice Arnold, who many of those listening will have heard of, he said he thought that even that was too slow. The mechanism for that was too slow in the context of this kind of situation where you're dealing with a pandemic, and that actually government intervention would be the way forward. But in terms of, I suppose, a slightly sort of more positive look at things, I just wanted to spend a few minutes talking about ways in which treatments and vaccines have been made available in the past couple of years. And really it goes back to what you were saying, Selin, regarding collaboration. And really the emphasis there is on how the pharmaceutical companies have reacted and behaved in this respect, rather than anything related to a waiver of rights. And I think that has been the key to where we've seen the access work. So the first area deserving mention and a few minutes discussion is that of patent pool initiatives. There have been several patent pools available during the COVID-19 pandemic, and the most active one of those is the Medicines Patent Pool, or MPP, and that's the United Nations-backed organisation working to increase access and facilitate the development of life-saving medicines. And its stated purpose, and this pre-existed the pandemic, is to encourage generic manufacture and also the development of new formulations. And up to the point of the pandemic, the majority of signatories to the MPP related to HIV retrovirals, but there have been some signatories relating to COVID-19. And as soon as the pandemic started, the MPP explicitly expanded its mandate for the purpose of COVID-19. A couple of particular mentions there, that in November 2019, Pfizer and separately MSD agreed to work with the MPP for licensing of antiviral pills and Pfizer's oral COVID treatments, and they made that access available in, I think, 105 countries. That, of course, is treatments rather than the vaccine, which I think is the focus of much of our discussion today. But I think it's still a good illustration of where that particular approach, more pharmaceutical-led approach, has worked. And those agreements that have been entered into are expected to enable mass production and low-cost distribution of those treatments around the world, with those companies I mentioned foregoing royalties while COVID-19 remains under, well, the pandemic classification remains in place from the WHO. So that's the success story in relation to those two products. I'm sure there are other examples that I haven't touched on, but it has facilitated early and cost-effective access to medicines. As far as we're aware, though, there are no pharmaceutical companies that have signed any agreement with the MPP regarding COVID-19 vaccines. But it is worth mentioning that in May 2020, so again very quickly after the pandemic began, the WHO called the MPP to join the COVID-19 Technology Access Pool, which is the global collaboration to accelerate the development, production and equitable access to COVID test treatments and vaccines. And that's based very much on the same principles as the MPP, and promoting the sharing, again, this word collaboration, and know-how through pooling in relation to voluntary arrangements. And developers of COVID-19 vaccine or products can use that system to facilitate the scale up and production through multiple manufacturers that have currently untapped capacity to scale up production. Once you have your technology in place, actually then becomes the challenge of expanding that. So I think this approach, this scale up, this use of untapped manufacturing capability has also had some notable successes, and I think through this route, but also just general collaboration amongst pharmaceutical companies has led to the maximal production of vaccines, and I think that's where we've really seen that big change happen. And I think it's true to say that as we sit here today, the world now has more vaccines than in fact it is able to administer. So that's, you know, on the one hand, great news from a vaccine point of view, but the challenge then shifts to administration and assisting particularly developing countries in making sure that those routes to patients are available. And that perhaps just underlines the point made at the beginning regarding the IP waiver, that challenge does not relate to IP, it relates to something quite different, which of course we all still need to work to resolve, but it is not limited. IP is not the rate limiting step in that, and I think that's really important to keep in mind. So just a few statistics. I think in 2021, 11.2 billion COVID vaccines were manufactured, and that would have been sufficient to vaccinate 70% of the global population, and that met the WHO's target. So that's a bit of a story around patent pools and that success, and the way in which the actual manufacture has really taken place in circumstances where the patentees have kept a degree of control over what's happening, but have still obviously made that massive and really important impact. For completeness, just along the same lines, and this has been touched on already, I did just want to mention the mRNA technology transfer program. I think this is an interesting one. Again, this is a global initiative that aims to improve health and health security by establishing locally owned mRNA manufacturing capabilities for low and middle income countries. The programme is based around a technology transfer hub, Afrigen, which is in South Africa, and the idea is that they will provide the technology development, the training, the technology transfer, and be a hub to allow that technology to be developed and available elsewhere where it's most needed. And the way in which they've done that is by using publicly available information from the existing Moderna vaccine. And Afrigen have been able to create their own version. And as I say, I think that's been mentioned already. And as I understand it, that is the first mRNA vaccine that has been designed, developed and produced in Africa. We also understand, though, that Moderna themselves plans to develop a manufacturing plant in Africa. And it's unclear to me at this stage exactly what collaboration there might be in this regard. And as mentioned right at the beginning, of course, Moderna has made a statement that they won't enforce their IP in at least South Africa, and I think more broadly as well. So that facility is moving and up and running, but they're all very recent developments, and of course wouldn't ever have happened as quickly as the development of the vaccine in the first place. So just moving away from that, the collaboration side of things, I think we also need to talk briefly about the Kovacs Initiative, which I'm sure everybody is aware of, but just to talk about it very briefly, this is the international mechanism which is led by the Vaccine Alliance and the Coalition for Epidemic Preparedness and Innovations and the WHO, with the aim of accelerating the development and manufacture of COVID-19 vaccines to guarantee fair and equitable access in every country in the world. And their delivery partner, touching again on this key aspect of delivery, is UNICEF. So far 33 countries have joined to support this and make vaccine donations. Again, I like my statistics. I think 1.1 billion doses have been sent to a total of 144 countries via this route. And the African Vaccine Acquisition Trust, launched by the African Union, is going to work with, or is working with, Kovacs, particularly across Africa, to really boost that vaccination rate, which does remain very low, and a lot of pharmaceutical companies are also working with them to support that stage of delivery. Just very briefly, a few numbers there from some of the vaccine manufacturers. I think Pfizer-BioNTech, they announced on the 3rd of April that they'd shipped 3.3 billion vaccines to 179 countries through this route. They've also pledged to support the needs of the frontline medical healthcare workers out there. J&J, 200 million vaccine doses, and Moderna, I think, have agreements in place for the supply of 650 million doses. But acknowledge through all of that the rate limiting step there is administration, storage, distribution networks, etc. So that I think is just a sort of wrap up of where we are, and with that I am going to hand back to Aysel, Selin and Jordan.
Thank you, Camilla. I mean, it is quite fascinating to these initiatives, the Kovacs and the CTAP. And when I'm listening to you, I could not help to ask myself, would these initiatives be possible to run if IP was waived? You know, if there is no IP at all, how we will pursue the, you know, collaborators, the companies, to come up with whatever they have in their hand, because IP is not only about monopoly. It is also about, of course, I mean, control of the rights. They want, of course, they invest a lot, of course, and they want it to be in control of these rights.
Yeah.
They want to be in a position willingly sharing it, etc. So these two initiatives are quite important, and the statistics you gave are striking. I think it's very important to have a look into it.
Yeah.
And also, I think you also mentioned about MPP, which is also interesting and is a good solution. You said it started with the collaboration with WTO, or what did you say? I think I missed that point.
I think it started, it's been established for some time, and it, yeah, the WHO.
Yeah.
Yeah.
Well, again, I think we could have made our point about what we really need, but I also know that some kind of thinking is saying that, you know, this, especially IP waiver advocates, think that if we just remove the IP, everything will be so smooth. But when we look at the plan behind it, especially what incentive we will find to put to motivate the innovation, there is no response. So that's why I really do not believe that it is a true solution. One other thing is about this running the compulsory licensing mechanisms, especially. I know that it was debatable, and I also read about a very interesting article which says that, yeah, you can grant compulsory licensing, but you cannot you know, force anyone to share the trade secrets or the know-how. So is it possible to, you know, compulsory license the know-how? Is it possible? Is there any such mechanism? Okay, very interesting point of view, and very dangerous once again, because you will be in a position saying that, yeah, go be free, invest in everything you want, and, you know, innovate, but I cannot assure you what will maybe in future I may need to put a gun on your head and say that give everything to me, what is valuable to you, because the IP, trade secret, know-how is the most important assets of the innovative company. We all know it. Again, a very dangerous trap, I think, to raise. Instead of looking what we could find as a solution, does not need any of this. So why not to, you know, support these initiatives, to create more of them, maybe? I really have difficulty to understand that. One last thing, when I was again trying to, in my little world, trying to find out what else solutions can be brought, instead of, you know, forcing IP owners to give up on something or to force them to collaborate, etc., by other kind of threats, of course, which we can all imagine. I thought that the pressure should be put on the governments instead of the companies.
Yeah, I was just going to say, Sinem, it's so important. Yeah. We need to think about, especially high-income countries must support.
Yeah, I mean,
low-income countries.
I'm not an expert of this procurement issue, etc., but why not? One can say that for every number of vaccine you order, you have to donate half of it, irrespective from your own population's need, because it is a very correct criticism that I read, that many well-developed and rich countries, they stocked these vaccines for the booster doses, etc. So yeah, there must be a solution. When I mean, if you just could vaccinate the half of your population, then you, instead of the booster doses, you should risk something as well, and you should donate half of it maybe. And if every country does it, I do not think so that there will be a problem for access to vaccine. Maybe too, optimistic, I do not know, but for sure, a better solution to, a realistic solution at least, to put the pressure on IP. And
also when they pay, they must be very generous, because at the end of the day, they're gonna all invest for the art, research and development and innovation, so they can be generous.
Yeah.
On this.
I also tried to make that point. A very important information, I think. This COVID-19 vaccine studies were, rooting from the old studies that were already conducted by these companies. The aim was not, of course, the COVID-19 pandemic. The aim was curing cancer or some other, illnesses, etc. But because that research was already started, we could took this path fast. So if you kill this incentive at this point, and you cannot know what is waiting for you next.
Yeah, and I think that's something we've not touched on in any detail, but a lot of the patents are the granted patents that pre-existed before the pandemic, of course, are platform patents that would cover the basis of those alternative innovations. And whilst any waiver, of course, would be limited to COVID-19, it would also facilitate the manufacture of the technology and the understanding, and may lead to problems further down the line, unrelated to COVID-19. So I think there's an additional danger there, because many of the patents that will be granted as a result of the work done on COVID-19 will be nowhere near grant. They're not available for this kind of waiver. They're sometime in the future. So I think that the time, and we touched on the complexity of any compulsory licensing, it's going to take a lot of time. These patents, the kind of the most pertinent patents, are not near grant yet, and those that pre-existed for other reasons, as you've already said. So I think it's another reason to proceed with caution.
I also want to share one interesting thing. Recently, WIPO published a report and found that a total number of patents are 5,300 related to COVID-19 were filed internationally from January 2020 and to September 2021. And university and public research organization played an especially significant role in developing vaccines, 44%, which is quite high if you consider all. So it's also interesting numbers, figures. So that's also showing us, make a balance between the IP rights and also access to the vaccine or other, products, whatever is needed in the, epidemic situation. As far as I know, we only have 2 examples compulsory licensing in terms of granted. One of them is from Israel. Israel granted compulsory license. Yeah, one of them from Agri's product to import, but of course it's a certain period of time. And the other one is domestic one from Russia. Russia granted 1-year compulsory license to the domestic generic company, which is related to Gilead's patents. But Gilead opposed this compulsory license decision of the Russian government. But as far as we know, Gilead's appeal was rejected by the Supreme Court of Russia. Apart from these 2 examples, I don't really have any other information that they granted. We also have one in Turkey, but still it's not very. We don't know the details, and it doesn't really.
But that one is not about vaccines, right? Because it is about a small molecule.
Yeah, exactly. Tablets. Yeah, tablet form. Yeah, I think this tablet is still in the pool. Just Camilla mentioned.
It was interesting. That was already in the MPP, and the company at the beginning of the pandemic said that I'm not going to enforce any patent rights against anyone who's trying to find a cure for COVID-19, etc. So I didn't understand that. I mean, no one could understand because there is no announcement and no steps could be taken. Unlike it was described in the law. So it is just yeah, everything happened, you know, behind the black curtain, and we are.
Yeah, that's why. Yeah, drug makers, although innovative companies, one of their hesitation, one of their concern or problem, maybe is more than hesitation. All these compulsory license proceedings must be very transparent, in a transparent manner. This is the problem. That's why they are, when they hear the compulsory license, they have, you know, more resistance on this issue, because we have some problems with this. That's why European Commission is trying to maybe unify or harmonize all the regulations between the various EU countries, which may help to standards the compulsory licensing procedure.
Yeah. So in terms of timing, I think we need to take the questions right now. If Jordan can help us with any questions.
Yeah, absolutely. So thank you all very much for that. That was really insightful. We've had a couple of questions there from our audience. The first one is for Camilla. I know you spoke about this earlier, but the WHO claims that Africa is ready or almost ready to start producing mRNA vaccines, and would like the collaboration of Moderna. So why Moderna?
Yeah, good question. It's really interesting to see that Moderna have obviously been the target, or at least the Moderna vaccine has been the target of the work that they've been doing in Africa. My understanding is that that particularly mRNA was chosen because it does tend to be, whilst it is obviously a complex technology, but it tends to be a simpler means of production of vaccines than and quicker and easier to reproduce than other vaccine types. So that's, I think, where the mRNA side of that came from. And then I think Moderna themselves made quite a lot of additional information, so information above and beyond that which would appear in the patent available, and that has allowed them to focus and to use that information plus what's in the patent to try to reproduce the Moderna vaccine in particular. And of course, as I mentioned, Moderna have confirmed, particularly in relation to South Africa, that they will not enforce their patent. So I think that all kind of adds up to why the Moderna vaccine, why Moderna in particular. Good question.
Perfect. Thank you very much. And another question there for you. I mean, of the successes that you've outlined, which aspects do you think would be more reproducible in the awful situation that there is a further pandemic?
Yeah, I think well, again, sort of thinking about this, and obviously it comes up in our work, but also in preparing for today. You know, what is it that would make it our response, the world's response, quicker next time? I think in answering that, it's probably important to remember that many of the things that I talked about, in particular the MPP, that didn't just sort of come from a standing start. Actually, that was pre-existing for other reasons. So I would assume that they would continue. But I think really at the heart of it is what we've talked about, the collaboration. The collaboration is between pharmaceutical companies, supply chain, etc. Is what's worked. And I would say that if this were, you know, the worst was to happen, that there will be a lot of things learned from that collaboration where it's, you know, wouldn't have been the way in which those companies might have ever interacted before. There will be trust, there will be technology, capacity available that would still be available. And I think Kovacs, obviously that approach and touching on what we were talking about before has really worked. Actually manufacture, if you know what you're doing, you can get the manufacturing done. And actually encouraging the donations we touched on, you know, encouraging governments to donate, allowing pharmaceutical companies maybe to sell at a not-for-profit price, whatever it may be, but avoid the situation that was at the beginning of the pandemic. I know the UK did it, I know other countries did it, you know, vaccine stocking, let's get our own supply, let's look after ourselves. Actually, I think another time governments would know that they need to react differently to that, to make sure, you know, you need to be there to make sure that you can protect your country, but also make sure that you're doing that in a way that is equitable and helping those countries that might not otherwise be able to get that access. I think I would just add that that's all on the basis that that pharmaceutical company innovation will continue and would be available another time for a different type of vaccine, etc. And that really, I think that's at the heart of what we've been talking about today. So to reproduce the speed with which that vaccine was very first made available is going to be key, and put our faith in the pharma companies to help that happen. I hope that answers the question,
Yeah,
or at least give my view on the answer to the question. I'm not suggesting I have all the answers.
We've got another question in for Aysel now. How can a balance be maintained between the patent protection under the TRIPS agreement and access to COVID vaccines?
No, another good question, really. I believe that especially good cooperation between the high-income countries can create a balance between the patent rights and access to vaccines. As we all discussing, high-income countries can support the low-income countries. Of course, we always can discuss and compulsory license if it is handled with the right approach, and this can provide a balance too. Especially if the patent holder, IP holder are given in a fair conditions, this process can be carried out in a transparent manner. This can be also a solution. And the other solution can be, as Camilla very well explained, all the pools, vaccine patent pools, Kovacs Initiative can be the solution. These are my solutions that I think that this will be the reasonable approach to consider.
Perfect, thank you very much. And I think we've got one final question now for Selin. So what are the complications in providing compulsory licenses for inventions related to COVID?
Well, okay, we actually responded to this one a couple of times, but the thing is, we're not, I personally am not against compulsory licensing mechanisms if they are used as per to the requirements, you know, set in the law, and especially in, you know, abusing the, if there's such a case, abusing the patent monopoly, etc. Of course, they may be used, but the thing is, when it comes to the vaccines, the biologics, especially for, I mean, they cannot be of help, let me say, to reach you to the vaccine or this complex product, whatever it is. We have to admit that unlike to a small molecule, here you have to access to the know-how and technology and the trade secrets of the innovating company. So that's why I do not believe mainly that compulsory licensing is useless, once again, when it comes to the solutions that we seek all for in the COVID-19 pandemic. But of course, again, if there is an abuse of IP rights, if there is a true public interest, and if it is possible really when you run this procedure, if you will achieve something really, then why not? I'm not that against to the compulsory licensing.
Perfect, thank you so much. Well, I think that's a really wonderful place to finish today's webinar. On behalf of everyone at Mondac, I'd really like to thank our panel today. Selin, Aysel and Camilla, thank you so much for your time and for the compelling insights today. We really hope that we can have you back again with us in the future. I'd also like to thank our audience for being with us today. If you sent a question in, we didn't have time to answer it. I do encourage you to get in touch with our panel. The contact information will be made available along with today's slides and a recording of the session. So for now, thank you very much, goodbye, and I wish you all a wonderful rest of your day. Many thanks.
Thank you.
Thank you. Bye-bye.